The state will be recalling the previous witness, Lieutenant Colonel Rapadu, but a debate has arisen between the state and the defense as to the injection or the transplanting of the given in the trial with that the evidence that he gave in the trial within a trial, keeping in mind that the trial within a trial is a watertight compartment, that the evidence that he gave in the trial within a trial be transplanted or injected in the main trial, but we couldn't reach consensus on that point, and we just briefly want to address the court on that. In the earlier decisions, and I'm referring to the case of State versus Sitebe, the citation is 1992, Volume 2, SACR 346, and is the decision of the Appellate Division at page 351 from paragraphs C.
Wait. Mr. Ngomezulu, have you listened to your colleague?
Yes, ma'am. That's correct.
So what is your decision?
My Lord, as it has been discussed that the witness will proceed from where he ended on the evidence that has been redacted, because the evidence that is tendered during the trial, within the trial, should be, this witness should continue by giving evidence or reading the statements that were attached on a pro forma, which were redacted during the trial, within the trial.
Is that the agreement with the state?
Yes, that's
But
what.
Mr. Balu is not saying that. Mr. Pidi, what did you agree with the state, if anything?
If anything, my Lord, we did not agree, but my position is that, my Lord, since the trial within a trial was insulated, and now we are no longer dealing with admissibility, my take is that that evidence now forms part of this evidence, because he's continuing with the annexure. We go into the parts that were withheld for the purposes of the trial within a trial, my Lord. That's my understanding, subject to.
Mr. Nisi?
That is my understanding as well, man. I think that was asked something.
You want to take up something with the witness?
Yes.
In a trial within a trial?
In the evidence that he provided in the trial, within the trial, you can still go back to his evidence in the trial, within the trial, and take up him on those issues.
Yeah, fine,
Which is the reason why that evidence will basically form part of the main trial.
Which evidence are you talking of?
I'm talking about the evidence.
The
that
pro forma evidence?
Yes.
Yeah. Yes, Mr. Mumalu?
Thank you, madam.
But the court has made a ruling.
Hello?
The court has made a ruling about the admissibility of the statement, so it is for the witness to continue from where he ended on the last occasion. Thank you.
Yes, Ms. Mshololo?
Thank you, my Lord. My Lord, also to add on that, it's that in the pro forma itself, my Lord, you'll recall that there were other paragraphs which were blocked.
Yeah.
And then now they have to be revealed and read into the record. That's the procedure that we need to follow from now onwards, my Lord.
Okay.
Thank you, my Lord.
What are you saying?
Well, we are saying, my Lord, that there has to be some sort of an agreement that the evidence that was given in a trial, within a trial of a specific witness, be injected, be transplanted in the main trial, so that this witness doesn't have to repeat what he testified to. Must keep in mind, as Mr. Ramusipili mentioned, that trial within trial is watertight, is insulated. So basically we're starting now on a clean slate. And it's crucial that, and this is what the authorities are saying, that, there has to be, that
Yeah,
agreement.
just read those authorities as you say.
Yes.
You say
Yeah, starting with Sitebe, my lord,
Yeah.
1992, volume 1, SACR 346, is the decision of the AD at 351 C to D.
and
This is what, this
who
was
were
the,
the judges there?
yes, the judge was Van Heeren, Ninaber, and Nicholas, AJA. Initially, they laid down a very straitjacket approach, and in paragraph C to D, they held as follows: in principle, unless the parties stipulate to that effect, neither the defense of the accused nor of the state witness given during the trial within a trial ought therefore to be injected in the main trial. So in other words, they say there has to be, an agreement to that effect.
So that's inclusive in the pro forma evidence.
Indeed, my lord.
Yeah, because
Yes.
that is, if you want to be fancy, it's res judicata.
Yes.
Okay.
Yes, but this approach was later watered down, my lord, in the very same SCA in the matter of State versus Nhlengetwa.
Ntlengetwa, okay.
It's
Which year was it? Ntlengetwa?
1996,
Oh, okay.
volume 1.
Yeah,
We'll remember the Sitebe was earlier in 1992. So 4 years later,
yeah.
in the matter of State versus Nhlengetwa, 1996, 1, SACR
Page,
at 737,
yeah.
and they held as follows. I'm reading from the head note at the bottom of the page. In SD Fries 1989, volume 1, SA 228, appellate division decision, it was held that an accused evidence during the trial within a trial could not be held against him in determining his guilt.
Yeah.
I'm sorry.
Yeah, no, fine.
This does not mean, however, that those parts of the state's evidence relevant in respect of guilt and which had been presented before the full court cannot also be taken into account. We go on. If a trial is conducted by either a judge alone or a magistrate, it is nonsensical and a waste of cost, time, and energy to repeat evidence which was presented during the trial within a trial at the end of such trial within a trial. So in other words, my lord, they say it's not necessary to repeat the
Those are 5 judges. 3.
three.
3. Rams also.
Yes.
There are issues which he wants to take up with the kennel regarding his evidence in the pro forma. Is that what you're saying, sir?
My lord, basically the process here is, the court would remember that.
No, let's, is that what you're saying? You want to re-cross-examine this witness regarding the pro forma. Let's not complicate the law.
What I'm saying, my lord,
Yeah.
is if there are aspects that this witness testified about
Where?
within a trial on the performer,
Right?
and I want to take him up on them,
No.
I am welcome to do that.
No, you're not. Quote me the authority. I can, again, quote me the authority.
That's the procedure.
Yes, quote me the authority. He's been quoting the authority. I don't know that procedure.
Otherwise, that is going to be very irregular.
No, quote the authority.
I might not have that authority now, my lord, but that's the
No,
procedure.
Ala Jen. How many days do you want? Ala Jen, quote the authority.
Okay, no, it's fine.
No. You can't make a statement about the law, and when the judge says quote the authority, you say, no, it's okay. Sir, Mr. Baloi, do you know of that authority? Which says you can again cross-examine this witness concerning the pro forma. after having done so.
Yes, yeah.
Hello?
Well, there's that case of Krecher by Judge Lamont, which says the court should adopt a somewhat flexible approach. It will be up to the court to decide whether it allows such cross-examination.
So that judgment was written by Lamont.
Yes, in the Krecher case.
Do you have it here?
I'll be able to look. I don't have it at hand. But
Do you have any judgment besides the judgment of Lamont?
No,
You're
no.
sitting alone.
No, I don't have any other judgment, my lord.
Do you have any judgment?
No.
Either even if it's in Namibia
No.
or even in Zimbabwe, which says
No,
exactly what Mr. Mnisi is saying.
no. I'm not aware of, except for this one that I've quoted.
Okay, let's hear the other authorities.
Yes, continue from where we left off. There's that other matter of State versus Bakani and others.
Yeah, I'm aware of that.
It's 2017, Volume 1, SACR 576. This matter went on appeal, and
Before Preller.
the SCA did set aside the judgment on the merits. However, some of the principles that were distilled remain in place. For instance, on page 582, paragraph 20, the court says the following: as it is usually happens in matters of this nature, the parties in casu agreed that the evidence led by the state in the trial within a trial will form part of the main trial to circumvent a situation where the witness would have to lead the same evidence
Yeah, that's the law I know.
and be subjected to cross-examination
Yeah.
again. Yes, I think just underscores
Yeah.
what
I've
the,
never heard of that. Never, ever.
what
Been in
the-
the criminal courts donkey years. Okay,
yes. Then perhaps the last case then is that one of State versus Muchindu.
yeah, that's
but, yeah.
where he says sometimes you can't differentiate between the evidence, which, just read it also.
Yes,
Because Mr.
it's
Ngumalo
two-
once read it.
It's 2000, Volume 2, SACR 313.
Yeah, what does it say?
Shoots
Shoots, yeah.
Day, yes. It says, and I'm just reading the headline, the head note: it is not necessary for evidence which has already been led in the main trial to be led in a trial within a trial. If the parties wish to refer to such evidence and the court is entitled to rely on such evidence. And then on page 317, at paragraph H, he says, accordingly, I rule that during the course of this trial within a trial, reference may be made to evidence already led in the main trial, and that the court is entitled to rely on such evidence as may be appropriate. My lord, he's just saying that,
The opposite.
yeah,
Yeah, that is permissible.
he-
Where,
he's
for
holding
instance, the colonel says I was born in 1920.
yes. And
Then
just,
they can come in the trial within the trial. That evidence can be admissible.
yes,
It's the other way around, because that is the merits being infused
yes,
into the evidence in the trial within the trial, where it is common cause.
yes, yeah.
Okay.
And then lastly, the author Himstra criminal procedure at 2462,
2462.
yes, 2462,
What's the IMTA?
in the heading repetition in the main trial of evidence given in a trial within a trial, he says, when there was a trial within a trial, those parts of the state evidence which are relevant to the main trial can be taken into account without being repeated. Says it is an unnecessary waste of money to repeat that evidence
fine.
in the trial. Then he quotes the decisions of Nhlengetwa as well as Muchindu.
So basically, those decisions are saying that what has transpired in a trial within a trial, meaning including the evidence which was led in the pro forma by the person who ultimately writes down the statement or the confession.
Yes.
And he or she has been cross-examined. So are you saying they're saying there is no procedure which says he must also be cross-examined on the evidence led within a trial, understand the law?
That to refer to.
Yeah,
Yes.
but it happens with
Definitely.
he doesn't have to be in a trial within a trial. It happens, as Mr. Ngomezulu can tell you, it happens with any evidence. Once a witness has been cross-examined, you can't cross-examine him again unless you get a special dispensation from the court and unless there's a just cause which you present.
Yes.
Okay, what
Okay,
else?
then just finally, the writer, Ditoi,
Tell you, what does he
and
say?
others' commentary on the criminal procedure at 2466H
Yeah,
poses the question, if an accused evidence during the trial within a trial cannot be held against him in determining his guilt, that is
yeah,
now in the
you can't.
trial in the main trial, does this mean that those parts of the state's evidence relevant to his guilt can also not be taken into account? Then the writers say no, said the court in S versus Nhlengetwa, provided such evidence has been presented before the full court, including the assessors where they're sitting with the judge. It would be nonsensical and a waste of cost, time and energy, said Haram's JA, to repeat evidence which was presented during the trial within a trial at the end of that procedure. He recognized that such a step might be a deviation from existing practice, and he also refers to the case of State versus Bakani and others, where the majority referred to Nhlengetwa's case in holding evidence adduced by the state at the trial within a trial to be admissible at the main trial for the purpose of confirming the confession. So in short, my lord, our contention is that the evidence of the witness who have been recalled, because basically this witness is
Yeah.
being recalled, it's already testified
That's it, yeah.
that, and I think that is the effect of the
The law.
submission by Mr. Ramsepeli and Mr. Ngomezulu that
Yes.
they continue from where they left off.
Yeah,
But
that's what
just-
the law says.
Yeah, but just to avoid any uncertainty in this regard, we submit that the evidence of this witness, on all those witnesses who have been recalled, or to formally be injected or transplanted in the main trial.
Okay. Any response from any person, any counsel? Mr. Ngomezulu, you stand by what you said.
No response, ma'am.
Mr. Ramsepeli?
As the court pleases, my lord, I hear the authorities and I cannot off the top of my head because the one that I had was the culture one because
Which
I've
one?
got it here.
Which one?
The culture matter. But my concern, and I concur with Mr. Muniz, is this. There were certain parts in the pro forma that were redacted that the witness that's been recalled was never
They never
cross-examined
testified
on.
on them.
So we leave them as
Yes.
that. Then I'm indebted to the
Even
court.
this court,
Yes.
you all refused for this court against the law. You refused that I should know what is redacted. You remember?
No, I'm
You remember
indebted
that?
now.
You refused. And I said, okay,
Yes.
I haven't quoted case 1952, quoted an SAA case
Yes.
of 1952 which says I can and I should. But I just abided with what you were saying.
No,
Now,
we-
those redacted parts, he was never permitted to read them.
Yes.
And they were never read. So he's not going to read them.
Okay. No, I'm indebted to the court.
Yeah. Okay, let's start. Can you swear the witness in again?
Your full names and surnames. present in this court will be the truth.
So help me.
Yes, to first read everything.
My Lord, sorry, Mr. Mgomo.
All right.
There was one paragraph, my lord, that was redacted and that was not put in record, but the court has ruled that that part cannot be put on record.
No, just repeat what you're saying.
There
It was redacted.
Yes, there was one paragraph. That paragraph has not been put on record.
And it was redacted.
Yes.
In other words, this witness, if he read it,
Ability of the statement to be determined. And now,
The information that is redacted, that is in the erroneous form, should not be read
Yeah.
out now. Then that's the reason why I said the state cannot make that application because the court will already ruled on it. But the procedure.
but you see, that's, yeah,
Everything must then be read.
I hear you. You see, I wasn't there when you agreed.
No, there was no agreement.
He says there was an agreement.
No.
Mr. Baloyi, was there an agreement?
Definitely.
it is about excluding certain portions.
Then they will be excluded.
Yes,
And
until the decision on admissibility. But now that admissibility has been determined, then we go back to those parts that were,
Is that the agreement you
Bloated.
had with your colleagues?
yeah.
Hello?
Well, that was the import of the discussions. You know, I don't want to put it higher than, you know, that was a discussion. But if my learned friends are at idiom with that approach, we can just simply go ahead and put those portions on record.
My lord, can I make just one submission, my lord?
Yeah.
My lord, for the sake of progress, my lord, I'm just appealing with the court that we just let the witness to go through with this document, my lord, the way the state is intending to do in this
Are
document.
you all agreed on that? All of you? Are you all agreed on that? You said you're acting as a team. Are you all agreeing with Mr. Msololo when he says that should happen?
I agree with Mrs. Mshalom.
Mr. Ramsey,
I do agree, my lord. Thank you.
you agree?
Yes.
That means you agree also now.
My lord, it's not a question of me simply agreeing. That simply means those parts which were redacted, that this witness was not cross-examined on, we should be given an opportunity to quiz them in an event that we have questions on them.
Okay, yes. You can proceed, Mr. Baloyi.
As the court pleases us, I don't know if my learned friends want to say something, but Lieutenant Colonel Mboto, you've already given evidence regarding Exhibit HH.
Is that Mboto?
I'm sorry, Colonel Rapadi.
Yeah. Yeah, it's already being sworn in again.
Lieutenant Colonel Rapadu, you've already given evidence regarding Exhibit HH. I just want to refer you to paragraph 15.1, which was redacted. It appears on page 4 of Exhibit HH. If you can just put that on record, paragraph 15.1.
Are you still prepared to make a statement? I would like to know your source of information regarding the proposed statement you wish to make. And then the accused response was, I was involved in the crime scene.
Manje ke usuke waphana ngobufakazi manje kunalapho kazanye ungaphananga ngaloko bufakazi. Ngicela ungifundele lapho ku 15.1 ithi ke usazimisela ukuthi wenze istatement wena ngifuna ukwazi ukuthi lolo lwazi ulithathaphi ukuthi ngizoqhubeka ngalesi statement bese impendulo ize ithi mina ngangiyingxenye yalokwenzeka kwaleso sigameko.
Thank you. If you can then turn to page 5 of Exhibit HH. Paragraph 17, you've already put the contents of paragraph 17.1, 17.2. If you can just perhaps read once again 17 just to give context for the record, paragraph 17, then proceed to 17.3.
Since it appears that the deponent is in his sound, sober senses, he had not been unduly influenced thereto, understand his rights as prescribed by Section 35 of the final Constitution, and freely and voluntarily wishes to make a statement, he is informed that he or she may now proceed.
Njengoba ke umsolwa yena eseka azisi ebonakala ukuthi wayekade ekumqabango olungile, yena ke manje akazange aphoqwe futhi uyazwisisa amalungelo wakhe ukuya ngomthetho sisekelo owalapha eMzantsi Afrika. Yena uzimisele ngokwakhe ukuthi angayenza istatement leso futhi uyacebiswa ngokuthi kuzoyenzakalani uma eqhubeka.
Yes, you can then proceed to the annexure itself. And maybe just before you put the contents of the annexure, can you just maybe give a background? How did you go about taking down what is stated in the annexure?
My Lord, I made sure that the accused person understands. The first thing that I've explained him was his right, just as a matter of remembrance.
Ngaphambi kokuthi uthathe lesi statement wenzeni uthi ngiyenze isiqiniseko sokuthi umsolwa uyazwisisa amalungelo wakhe ukumkhumbuza nje.
I made sure that he's of sober mind.
Ngingayenza nesiqiniseko sokuthi yena wayekade umqondo wakhe wawukade ulungile.
And the statement was made voluntarily.
Nokuthi lesi statement yena usenze engaphoqwanga.
Without any undue circumstances.
Engazange ethenjiswe mhlawumbe into ethize noma angazange atshelwe into ethize.
Yes, we'll proceed.
It's then that I started sitting down with him, going into the statement itself.
Kula ukuthi ke uKennel uye wahlala phansi naye waqhubeka ngaleso statement kusona engena odabeni.
Yes.
Can I read the contents thereof?
Yes.
Which I took. You first explained me the statement, and then later on, I went on to say, now I'm writing, paragraph by paragraph. I mean, sentence by sentence.
Umsolwa ke uqale watshela uKennel istatement ngemva kwalokho uKennel wamtshela ke ukuthi sengizobhala yonke into ewungitshela yona njengoba ungitshela yona ngizoyibhala ngaleyo ndlela.
Then we started. I, Bongani Sandiso Ntanzi, 30 years of age, 3125 Freedom Park, 2, Rustenburg states the following in Zulu and translated into English that
Yeah, just a minute now. Those details that you mentioned there, the name, the age, the address, where does that come from? Where did
No,
you,
no, no, no.
as a court pleases?
No, 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 no. The procedure is this witness must read what
Yes.
he wrote down. It doesn't have to be cross-examined, asked.
It was just a clarification,
No,
Madam.
no,
That-
it
but
doesn't
that is
clarify-
fine.
That's not what the law says.
We leave it at that, yes. Yes, just read it as it is.
during mid-October 2014, I received a call from a friend, Mtoko Sizeni, who was with Mapisa. He informed me about an urgent work that needs to be done and they need my assistance.
Just a minute.
Mr. Ramsipili had said the witness should read the whole statement, then I will interpret after.
Okay, thank you. Yes.
He informed me, okay, I think I'm done with that.
Yes.
Carlos was nearby as I could hear his voice in the background. I promised to assist and I decided to leave for Johannesburg. I then left for Foslora's men's hostel. I then met with Muzi Sibia, Sifiso Zungu, also known as Nkani, who initially gave the inside information. Later, Carlos Buthelezi and Mapisa joined the gathering at the hostel. I was briefed that the person to be eliminated or killed was Senzo Meyiwa, and the matter is initiated by Kelly Kumar, who was going to make a payment for the whole job. We were positioned accordingly that Nkani will be the driver, Moses Sibia will be the guard, and myself and Carlos will get inside Kelly's house. Mapisa will be outside as a backup, and surveillance was conducted. Sunday at about between 1900 and 2000 hours, we then proceeded to the address. I went in with Carlos and others took their positions as discussed during the planning. When we entered the house, Carlos shouted in Zulu, "Phansi, imali ne my cell phone." I started collecting cell phones and cash that was in the container. While I was still busy, Senzo jumped to Carlos and the struggle ensued where one shot went off and the second shot hit Senzo as the firearm was pointed at his chest. I ran out with the money and the cell phone, leaving Carlos behind. While Mapisa ran into the house, I then proceeded directly to the silver Polo was parked. I waited in the car with Nkani. Within a short period of time, I was joined by Carlos, Musi Sibia, and Mapisa. We then left for Foslora's hostel. Carlos took the cash and the cell phone from me at the hostel. At the hostel, I received an amount of 15,000 cash. I then left with Nkani to Johannesburg, where I slept over. The following day, Nkani took me to Davidton, where I stayed from some days. Nkani later returned and took out an amount of 30,000 and gave me. He further directed me to the taxis to my residence. As there was a dissatisfaction about the money, it led to a meeting to be held in the homelands at Ematlatini. It escalated to such an extent that Musi Sibia had leaked information about the incident, murder of Senzo Meyiwa. Njabulo and Lulama had an argument with Musi Sibia, whereby a meeting was convened by the family headed by Musi's father. He told them to keep quiet about the incident of the killing of Senzo Meyiwa. The family agreed about the conspiracy to keep quiet about the incident. The matter was never reported to the police. I then left for Carltonville, later to Rustenburg.
Nasike istatement esifundwa uKennel. Lesi statement sika Bongani Sandiso Ntanzi bekade eneminyaka engamashumi amathathu ehlala e3125 Freedom Park 2 Rustenburg. Yena uye washo lezi zinto ezilandelayo ngesiZulu ezabhalwa zatolikelwa kwesilungu. Phakathi kwenyanga kaOctober ku2014 ngiye ngathola ucingo kumngani wami uMthokoziseni obekade enomaphisa. Wangicebisa ukuthi kunomsebenzi osheshayo odinga ukuthi wenziwe, kudingeka uncedo lwami. uCarlos bekakhona eduze njengoba bengade ngikwazi ukuzwa iphimbo lakhe emuva ekhuluma. Ngiye ngathembisa ukuthi ukunceda, ngathatha isinqumo sokuthi ngisuke ngiye eJohannesburg. Ngafika eFosloras ehostel yamadoda. Kula ngiye ngahlangana noMuzi Sibia, Sifiso Zungu, owaziwa futhi ngegama likaNkani. Ebaye siyesahlangana esangweni banginika ulwazi. uCarlos Buthelezi noMaphisa baye bafika baba nathi ehostel. Ngiye ngatshelwa ukuthi umuntu obekade kwamele asuswe kwakade kuSenzo Meyiwa. Leyo ndaba indaba ukuthi ize ngoKelly Khumalo obekade eyokhokhela ngalo msebenzi wonke. Siye sahlala ngendlela ukuthi sahlela ngendlela ukuthi uNkani wayekade ezoba umshayeli, uMuzi Sibia uzoba unogada, mina noCarlos sizongena endlini yakaKelly, uMaphisa uzoba ngaphandle njengomuntu ozabe esisiza noma ezabe esebenza umsebenzi phecelezi we-backup. Futhi kuzoba nomuntu ozabe ebheki leya ndawo leyana. Ngesonto ngabo 7 ntambama noma ngabo phakathi ko7 no8 ntambama ithema saya kulelo Kelly ebesikade sinikwe lona. Mina noCarlos nabanye siye sahlala kuyindawo lezi bekade sihlele ukuthi sizoba kuzo njengoba sasikade sikhulumile. Siye sangena endlini, uCarlos washo ngesiZulu wathi phansi imali nama cellphone. Mina ngiye ngaqoqa ama cellphone nemali ebezikade ziphakathi kwecontainer. Ithema kusaqhutshekwa kanjalo, uSenzo waqhumela uCarlos balwa la ukuthi kuye kwaba nokudubula. inhlamvu yesibini yadubula usenzo njengoba isibhamu sasikade sikhonjwe kuye. Njengoba isibhamu sasikade sikhombe kuye esifubeni. Ngiye ngagijimela ngaphandle nemali nama cellphone ngashiya uCarlos emuva. uMaphisa wagijimela endlini, mina ke ngiye ngagijimela kwimoto iPolo esilver labe ibekade ipakwe khona. Ngalinda emotweni nonkani la ikuthi ngemva kwesikhashanyana siyesa uMaphisa, uCarlos noMuzi noMaphisa bayebeza bazoba nathi. Sahamba ke saya eFosloras ehosteli. uCarlos wathatha imali nama cellphone kimi. Ehosteli ngiye ngathola imali elingana no 15,000 rand. Bese ngahamba nonkani siya eJohannesburg la ngiye ngalala khona. Kwilanga elandelelayo unkani uye wangithatha wangisa eDavidton la ngiye ngahlala khona amalangana. Unkani ngemva kwalokho wangithatha wanginika, unkani wabuya wanginika imali elingana no 30,000. Bese ke wangithatha wangisa emateksini walabe ngade ngihlala khona. Njengoba bekade ngingenelisekanga ngemali, kuye kwayenzeka ukuthi kugcine kube nomhlangano emakhaya emahlathini. Kuye kwenzeka ukuthi uMuzi Sibiya uye wakhipha ulwazi ngaloku bulawa kuka Senzo Meyiwa. Unjabulo noLulama, is it Lulama or Lule? Unjabulo noLulama baye baba nengxabano noMuzi Sibiya la ikuthi kwakade kunomhlangano womndeni wakhe obokade uhanjiswa ubaba kaMuzi Sibiya. Yena ke kula uye wabatshela ukuthi bathule ngalokubulawa kuka Senzo Meyiwa. Umndeni wavuma ukuthi bazogcina leyo mfihlo. Leli cala alizange lazisiwe emaphoyiseni. Mina ke ngiye ngahamba ngaya eCarltonville ngemva kwalokho ngaya eRustenburg. As the purposes, thank you my lord, I have just interpreted the statement. Nizwile madoda lento bengibele ngifu. The accused shakes nods their heads to show that they have understood.
Okay. No, Lieutenant Colonel, there are some signatures at the bottom and thumbprint. Can you just explain that?
Yes, the signatures belongs to me and the accused person. The thumbprint belongs to the accused person too.
Kuna la kusayinwe khona la phansi ngemva kwale statement ake uchaze ukuthi ubani osayinile futhi nesithupha esikabani, uthi signature enye yeyami enye eyakamsolwa futhi isithupha esabekwa lapho kwakade kwesakamsolwa.
Yes, and on the previous page, page 6, there appears signatures as well. And a thumbprint, can you just explain them?
The signatures belongs to me and the accused person's thumbprint.
Nakwile page le eyokuqala la kufundwe khona istatement page 6 kuna la kusayinwe khona nesithupha ezakabani uthi yimina ongisayinile nomsolwa wasayina wabeka nesithupha sakhe.
Can you just explain which one is your signature and which one is that of the deponent?
My one is on the far right at the end of the page, and his is the one on the left next to the thumbprint.
Manje ke kuthiwa achaze ukuthi yena usayine phi, ubonisa ukuthi yena usayine la ngakwesandla sokudla, umsolwa yena usayine ngakwesandla sosinxele eduze kwesithupha sakhe.
If we can then turn to page 5, paragraph 18.1. You've already put that on record, but just for the sake of clarity of the record, can you just once again put that on record?
Note down whether he also reads through the statement. The comment was yes.
Lapho ke kuye kwabhalwa lapha ku page 5 ukuthi bhala phansi ukuthi uye wafunda istatement na kuthiwa yebo, impendulo yakhona kube uyebo.
Yes, the statement was read back to him,
Yaphinda
and because he got an elementary education that he can read and understand the English. Later, I gave him the statement to him, and he read through, and he started. I said to him, he must sign if he agrees with the contents thereof.
manje ke uyaphinda ukhenela uthi istatement lesi njengoba ukuthi sibhalwe ngesingesi ngoba uNtanzi unalo ulwazi oluthize lesingesi uye wamnika istatement wathi nasi istatement ungasifunda nawe uma uqeda mase seweneselekile yonke into ebhalwe la kule statement ungasayina kula uNtanzi eyenza njalo wafunda makaqeda wasayina.
Yes. Just read paragraph 18.2, just put that on record. And the rest of the paragraphs.
Has the statement been read back to the deponent by you and the interpreter? Yes. I was standing in as his interpreter.
Istatement siye safundelwa umsolwa we netolikina uthi impendulo kube uyebo uyasho ukhenela ukuthi yena uye wathatha futhi nesigaba sokuthi kube utoliki.
Yes, paragraph 19.
The following questions are now put to the deponent. Are you satisfied that which you stated has been noted down correctly? The response was yes, and then
Impe kuyabuzwa ke ukuthi wena waneselekile na ukuthi istatement sibhalwe kahle impendulo ithe yebo.
do you have any complaints as to the manner in which I took down this statement? No.
Unesikhalazo ngalendlela emina ngithathe le statement ngaso uthi impendulo ithe cha.
Are you satisfied with the interpreter? Yes.
Weneselekile futhi nangotoliki uthi impendulo ithe yebo.
Place was Moroka, 2020-06-19, 11:47.
Lesi statement senziwe eMoroka ngonyaka ka2020 inyanga yaka June ngey 19 isikhathi kwakade ku 11:47.
He put his signature there and his thumbprint, and then I put my signature on the other side.
Bese ke umsolwa uya signa laphayana wabeka nesithupha bese uKennel naye wasayina.
The thumbprint underneath is his.
Nangaphansi kunala ayebeke isithupha futhi esakhe.
God, please, my Lord, will request that the annexure be handed up as an exhibit, as part of exhibit HH. We can mark it exhibit HH in brackets 1.
One. Yeah, but the kernel is not yet through reading.
Yes, we'll get to the other aspects, my lord. If you can just turn to page 6. And if you can just maybe put that on record as well.
Observation of the Justice of the Peace with regard to the deponent. Clothing. Clean blue jeans and Impala Platinum lumber. Appearance. Calm and responsive. Attitude, good and at ease.
Manje-ke,
Spontaneous, no, there was no response. I didn't write anything there.
manje-ke kuyabhekwa ukuthi ngemva kokuthi noma uKenneth uma ebheka ukuthi wawukade unjani untanzi wayekade enjani impahla zakhe zazikade zingangcolanga wayekade egqoke ijean eblue nelamba ye-Impala Platinum wayekade ebonakala kuumuntu ongathukanga kahle engathukanga.
Have you explained these signatures?
The signature of the Justice of the Peace is my signature and my full names. Here underneath the signature and the thumbprint on the far left is his, and on the right is my signature.
Uye wasayina yena njengomuntu ozimele ongaphenyi kuleli cala phecelezi uJustice of the Peace wabhala futhi negama lakhe namagama wakhe nesibongo kuyabonakala futhi nokuthi untanzi usayinile wafaka nesithupha sakhe bese futhi uyasayina futhi uKenneth.
Thank you. You've already put your evidence on record regarding the preamble, Exhibit HH. We're not going to repeat that. Do you confirm the correctness of the Exhibit HH1?
Correct, my lord.
Manje okuningi bese sokwenzile ngeke sisathu kuphinde wena uyavuma ukuthi lesi statement lesi siyiqiniso uthi yebo uyavuma.
We've already put on record the proficiency in the languages that were used. My lord, we beg leave to, as indicated, to hand it the annexure as Exhibit HH in brackets 1.
You say it's HH.
Yeah, HH in brackets 1.
Oh,
The
HH
annexure.
in brackets 1.
Yes, the annexure, the statement itself.
Yeah, okay, I hear you.
And with the permission of the court, if I can just ask 2 questions outside the statement itself. On page 6, your observation that the clothing is clean. It was put to the witnesses that the accused had not had a bath from the 16th of June 2020. What is your comment?
No, I will disagree with that.
Wena
On the day in question, the accused was brought to me. He was so clean that he was shining. So I didn't want to just write an exceptionally, but he looked like somebody who's working from somewhere. He was clean, my lord.
Kenel ubale ukuthi uma umbheka umsolwa ubone ukuthi wayekade elungile neimpahla zakhe zasikade singangcolanga kodwa abofakazi batshelwe ukuthi impahla zikamsolwa zasikade singcolile uthi cha impahla zakhe zasikade singangcolanga zasikade zibonisa njengomuntu osebenza endaweni ethize.
And it was also disputed that the that accused number 2 was given food. What is your comment?
Yes, I agree with that. He was given food during the process. It was early in the beginning, about maybe 8 o'clock in that morning. It was a meal for the prisoners. So they knocked, and then I went and fetched food for him, and then I gave him. I let him go through the food, and then when he was finished, then that we process, we continue with the statement.
Uyokwashiwo futhi nokuthi umsolwa akazange anikwe ukudla. uKenneth uthi lokho angivumelani nakho. Mina into engiyaziyo ukuthi umsolwa uye wanikwa ukudla obekade kulethelwe iboshwa ekseni kuye kwakokodwa laphayana nganikwa lokuyakudla ngamnika ngamyeka akhululeke adle aqede ngemva kwalokho kulaye ukuthi siye saqhubeka ngestatement.
And what did the meal consist of?
It was a buttered brown bread, and a tea.
Ukudla lokuyana kwakade kuyini uthi kwakade kuyisinkwa esi brown ebesikade sigcobiswe ibutter netiye.
What was the quantity of the bread?
It was 4 slices.
Sinkwa lesiyana sasikade singakanani uthi kwakade kungamaslayi amane.
Thank you, my lord. That is all.
Yes, Mr. Balo, is that the end of the evidence by...
Indeed, my lord.
Mr. Mnisi, you said there were things you wanted to take up. Which things are those? Hello?
I'm saying yes.
Yeah, what things are those?
I said there's no procedure with bars 1 when he wants to cross-examine.
Okay, cross-examine. Okay, cross-examine. Fine. Mr. Mbumezulu, do you want to cross-examine?
My lord, this is the witness for accused number 2.
Oh, yeah, by the
I
way.
think Mr. Ramsey
You are
Pidings.
on this.
Yes.
Mr. Rapis, any
What
cross-examination?
I wanted to say, my lord, that it should actually start with Mr. Ramusipi.
Okay. Let's hear Mr. Ramusepi.
As it persists, my lord, I would have thought by now my lord knows my surname very well. It's an easy to pronounce surname. My lord, I do have some questions for Colonel Rapadu. And I want to begin at the tail end. And also I noticed, my lord, we are closer to tea time, but I'll leave exactly at tea time. Colonel, you've just testified now that accused number 2, at the time he was brought to you, was fed, was given food. Is that your testimony?
Correct?
Uphane ngokufaka ukuthi umsolwa wesibini makeza kuwe uye wanikwa ukudla iqiniso lelo uthi yebo iqiniso.
Now, with my little understanding of police procedures, in order for the accused person to be fed, he must first be entered in the occurrence books of of that police station. Is that not correct? So that they know that he's there.
It was known that he's with me. That is why the food was, and all the relevant entries supposed to have been made.
Colonel, very well said indeed, because I was at various police stations. But we don't have the Morocco OB entry where it shows that accused number 2 was brought to you on the 19th of June 2020 at a specific time, and where he's entered into that book to show that you received him, you obtained the statement from him, and at a certain time then you handed him back to Jonathan, who brought him back to you.
That I do not know. I cannot tell whether the entries were made or not made.
I'm telling you as a fact. We've never received that. I'm not denying that it was made or not made, but as I'm standing here today, I've never had that side of that occurrence book.
I suggest relevant people have came to this court who's supposed to give you that evidence. I cannot, my lord.
Ulwazi lami onginalo ngalendlela ekusetshenzwa ngayo esiphoyiseni ukuthi umuntu uma ezonikwa ukudla kwamele yena kube ukuthi ufakiwe kwincwadi zesiphoyisa lezi ezibizwa phecelezi ama-occurrence book. La ukuthi umsolwa wesibili akazange abhalwe kwincwadi lezo. Uthi uKenneth wayekade kwazeka ukuthi unami umsolwa yingakho ewalethelwa ukudla. Ummeli uyaqhubeka uthi cha asinabo ubufakazi obuzile obubonisayo ukuthi umsolwa wayekade ebhaliwe kulezo incwadi. Uthi uKenneth ngiyathemba ukuthi abantu abathize noma mhlawumbe abekade bebhalile lapho bona baphane ngobufakazi lapha enkantolo.
Now, towards the tail end as well, you were speaking or testifying about whether or not the statement was read back to accused number 2, and you said that it was read back to him. Is that your Can you explain that for me?
Elementary education is you can read and write.
Imfundo le ngikhuluma ngayo uma ngithi umsolo wayekade enayo yile mfundo yokuthi umuntu uyakwazi ukufunda nokubhala. Nangokho engazange abe nayo umatikuletsheni kodwa umuntu loyo ubonakala njengomuntu okwaziyo ukufunda nokubhala.
Did you ask accused number 2 up to which standard or grade of schooling did he go?
Yes, I did ask.
Uye wambuza umsolo wesibili ukuthi ugcine phi esikolweni uthi yebo ngimuzile.
And what did he answer? What was his answer?
It was, I can't remember, it was a grade below the matric.
Uthi yena uye waphendula wathini uthi angisakhumbuli kodwa ungitshele ngaphansi ufunde ukuyofika ngaphansi komatikuletsheni.
And you also stated that you gave the statement to accused number 2 and he personally as well read it himself. Did I understand you correctly to say that?
It was after I interpreted it to him, and then I gave him to make sure that because I've spoken to the guy, that he got that education, but he can read and write. I gave him further the statement.
Uye wathi umsolwa uye wanikwa futhi leso statement ukuze asifunde naye uthi yebo bekungemva kokuthi mina ngangikade sengimtolikele izinto engizibhalile bese ngambona ukuthi yena uyakwazi ukufunda nokubhala kodwa ngingamnika leso statement ukuze asifunde ngokwakhe.
Now, accused number 2 has testified in this court that he is not the author or the source of the information contained in this statement, the annexure. And he testified further that if he wanted to write a confessional statement, he was going to write it in his own writing in isiZulu, because he understands isiZulu very well and he can write in isiZulu.
I will disagree with that. He is definitely the author of this.
Umsolwa yena ushilo ukuthi akusiyena umuntu obhale lesi statement futhi kube bekafuna ukwenza istatement asibhale wayekade ezosibhala ngesizulu ngoba uyakwazi ukubhala isizulu. uKenneth uyaphendula uthi mina angivumelani nalokho uyena umsolwa umuntu obhale lesi statement.
My Lord, is 11:18. Is it an opportune time to take the short agenda?
15 minutes.